said this stuff, and so my mom and her boyfriend was with the dad, and she smacked her car and stuff, and he was bleeding the head, and then he grabbed the bag and was like swinging her around and flipping stuff, and now there's just like destroying everything in the house that I don't know what to do, and I'm just scared. I just want to go to bed and go to school in the morning, but that's getting hurt.
Okay, back on the record in state of Michigan versus Carol Sherman, 2401405 FY, and we still have Ms. Chukas and Ms. James in the courtroom, Ms. Sherman and Mr. Nagel supervising because he's in the room. Nonetheless, have we decided what we're going to do next?
Your Honor, the people don't have our necessary witnesses here for the show cause, therefore we are seeking to dismiss that motion
Okay,
or withdraw that motion.
okay. So then as to the motion, pretrial motion for the admissibility of the hearsay statements.
Yes, Your Honor, that we are ready to proceed on.
Okay, go ahead.
Let's see if I have my. Apologize. Your Honor, the people are seeking to admit primarily two different portions of hearsay. The first is that from Chad Hammond. Chad Hammond spoke with, I believe it was Officer Craig Lesser soon after the incidents in this allegation or in this case, and that we believe it would be admissible under 768.27C, in that it is a statement that purported to narrate, describe, or explain the infliction of the injury. It is an action in which evidence is offered involves domestic violence. It was made at or near the time of infliction. The statement was made under circumstances to indicate trustworthiness, and it was made to an officer. The circumstances to indicate trustworthiness are that they were not made in contemplation of pending or anticipated litigation, that there was no bias or motive for fabricating the statement, that the statement was corroborated by evidence other than statements that are only admissible under this section. Officer Lesser was able to corroborate this with information from Briella Faze and via the 911 call, and also information that he video camera footage of part of the events. Regarding the statements made by Briella Faze to the 911 operator, the people anticipated it would be admissible under present sense impression, excited utterance, and the records of regularly conducted activities. The relevant the clips that the people have selected are clearly exempt from the confrontation clause because they are non-testimonial. They're clearly describing events that are actively happening, and the information is being relayed to get security to or law enforcement support to that scene.
Okay.
And I can play those clips if the court would like, just to ensure that they're testimonial. Or
Did you say they're redacted or?
They're trimmed. One is redacted just to remove Briella Faze's phone number, just because she is a minor, and I figure it's better not to introduce her phone number to the court.
Okay,
Would you like me to play those?
go ahead.
What's the location of your emergency? Hello. Hi. My address is 109 North Foster Avenue.
To 109 North Foster?
09 North Foster.
109?
Yeah.
Is that a house or an apartment? And what's your closest house street? What is your closest house street?
Sorry, what? What'd you say?
What's your closest cross street?
Michigan Avenue.
Okay. What's going on there?
My mom came home, and I don't know, my stepdad, my mom's boyfriend, they were arguing, and I don't know what happened. And I don't know what's going on because that's one morning, and my mom came home, and they were like always just yelling at each other and stuff, and so my mom and her boyfriend was with the dad, and she smacked her car and stuff, and he was bleeding the head, and then he grabbed the bag and was like swinging her around and flipping stuff, and now there's just like this going everything in the house that I don't know what to do, and I'm just scared. I just want to go to bed and go to school in the morning because I'm getting hurt.
Take a breath. Okay, so your mom hit her boyfriend in the head with a bat and he's bleeding. Okay, and you did confirm 109 North Foster. Okay, are you somewhere safe?
Stop near me.
How old are you?
I'm 12.
What's your name, hon?
My name is Briella Faith.
Briella?
Riella Faith.
And you're 12 years old?
Yes.
What's your phone number, hon?
My phone number is 517-930-9668.
Okay, is there a room in that house that you can get that is somewhere away from your mom and her boyfriend?
Yeah, my bedroom.
Okay, can you go to your bedroom?
Of course.
Okay, tell me when you get there. So you did say that her boyfriend is bleeding from the head, correct?
Yes.
Okay, hold on. I'm gonna start an ambulance for him, okay? Just stay on the phone with me. We got a lot of help coming out to you.
I don't want to say nothing much to my mom. She's the only person I really have. I love my grandparents. I don't want to live with them. And I believe in my dad. I think my mom just drank too much.
Just stay on the phone with me real quick while I talk to one of my partners, okay?
Of course.
I'm gonna have you stage on that Foster call. Male's bleeding from the head after he got hit with a baseball bat.
Okay, caller Stanley.
Okay, so you said your mom, what is her name?
It was Carol Sherman. CarolSherman.
I'm sorry, can you do the last name one more time?
Sherman, Sherman.
And do you know your mom's date of birth?
03/13/85.
Okay, and is your mom white, black, Asian, or Hispanic?
White.
Okay, and do you know what she's wearing tonight?
I think she's wearing a black hoodie. I don't know, but her hair's in a ponytail. As we're focused on stopping violence happening.
Yeah, you're doing great, okay? What is your mom's boyfriend's name?
Chad Hammond. They've been together previously.
And the part where she says they've been together previously and there's domestic violence in the past has been excluded from the clip I've made in the interest of complying with 769 or 768 27.
Okay,
That's clip one. The only thing that we've changed is we've removed her phone number. Clip two is
By the sounds of it, I'm pretty sure that my mom's boyfriend is outside and my mom's downstairs just destroying stuff.
Okay.
that is clip two.
can you play that second clip again, please?
Yes, Your Honor.
By the sounds of it, I'm pretty sure that my mom's boyfriend is outside and my mom's downstairs just destroying stuff.
Thank you. Okay, Miss James.
Thank you, Your Honor. Your Honor, first of all, there's so much wrong with this. I'm going to start with the filing of it. I do not believe it was filed timely. I believe that it lacked proper notice. According to the statute, notice that is required is 15 days. And I know the people alleged in their motion that I received on the eve of trial about 3 o'clock is that there is no intent They have no requirement to provide intent to use this information, but I think it's inherently in there. And if they really believe that, why did they title their motion, People's Notice of Intent to Introduce Hearsay Admissibility and Brief in Support of? So I think that they know that there was a notice. Even at a minimum, there is Michigan court rule notice of filing motions that require a hearing on law, on a question of law. That is by electronic 7 days. Then we have a requirement to respond. We have, we can respond. It's a requirement, or even if it's permitted. This is tantamount to nothing but a trial by ambush, what they're doing here. The show cause, and then this notice that they filed again on the eve of trial. And just to address it on the merits, Mr. Hammond's statement under 76827C is purely testimonial, and that's what it comes down to. His does not meet, his testimony, his statements were given to an officer later at the hospital. The officer made it clear that he went there to investigate what had happened. No matter how slight, it had already happened in the past. Mr. Hammond is in the hospital, he's safe. Furthermore, there's no ongoing emergency because Ms. Hammond is in custody. She has already been taken into custody. And I believe that case is right on point with the Davis case. There was no ongoing emergency. The officer said he went there to elicit, and that is further determined by their progression of comments. When the officer questions Chad, so tell me what happened, how did this start? He starts all the way back to earlier in the day. He's talking about past events that are purely testimonial, and my client would have a right to confront under Sixth Amendment. Chad's statements absolutely do not meet the 76827C ongoing emergency. Again, he was out in the hospital. It was a while after.
You're convoluting two, I think, two different things. The 768.27C and the ongoing emergency are unrelated.
But that's what they said, that there was an ongoing emergency.
Right, so that meets the statute, right? And you have a confrontation issue.
Exactly.
And they're saying
it was an ongoing emergency.
Right, which is separate from the statute.
But there was not an ongoing emergency. Again, Ms. Hammond, at the time the officer went to the hospital and elicited these statements, Ms. Hammond was already in custody. This was after it had happened. They were past events. It was completely investigatory. So it is testimonial, and I say that they don't come in. Also, in addressing Briella's statements, first I'm going to object to them even calling the dispatcher Julie Livernoise, again, for lack of notice. We received her name in an email, which I had missed because I went right down to the attachment Friday night. And then when I went back up over the weekend and looked at it, I saw her name and her phone number. Prosecutor is supposed to provide a witness list 30 days in advance. Of course, that can be amended.
According to
Michigan court rules.
For misdemeanors?
Okay, 30 days for felonies. I don't do a lot of misdemeanors, but what I will say, I'm certain that it is more than 1 day in advance. But we did not receive any witness list from them. You know, them calling this in, wanting to use these calls, providing this us to, wanting to use these out of court statements, providing it on the eve of trial at the 3-4 o'clock hour, not giving us time to do our due process. Of course, you know, prepare a proper defense that could affect strategy. It definitely.
James, you gotta try carefully because you told me you want to go to trial today regardless. So
and I do want to go to trial, but what I'm asking, Your Honor, is to not allow any of those statements in.
No, you either get more time to prepare or you get to go to trial today. Just to be clear, MCR 6.201 is not specifically applied to misdemeanors. It's exempt from the statement in MCR 6.001B that says which rules apply to misdemeanors. The rule on discovery is not applied. I do know that there's some separate constitutional, like Brady, et cetera, that requires some information, but they do not provide a mandatory timeframes for disclosure of witnesses or any of that as referenced by counsel.
And Your Honor, again, I am going to ask the court to strike Chad Hammond's statements as it was not an ongoing emergency and they are clearly testimonial and would violate Carol Sherman's Sixth Amendment right to confront. And as to the 911 calls, they're saying that they come in as hearsay, other exceptions. I am unaware of any hearsay exception that would trump, again, her right to confront and her Sixth Amendment constitutional right. So I'm asking the court to strike all of those out of court statements that the people would like to bring in, as well as the 911 call, and then proceed to trial.
The 911 call is coming in as a present sense impression, non-testimonial statement. It's clearly made under the ongoing emergency. You can hear that the event is still ongoing and that the child is clearly under distress. The closer call is whether Mr. Hammond's statements come in. Do we know where the child is at the time that Mr. Hammond is making the statement?
She has been picked up by a step grandmother
She's in the
away from the address where the incident occurred. Yes, she's in the care of a step grandmother.
Okay, and you believe that to be true, Ms. Kashukas?
She was either actively in the care or an officer was there awaiting for that person to arrive, yes.
So how is it an ongoing emergency if Mr. Hammond's at the hospital, Ms. Sherman's under arrest, and the child is now in the care of another relative?
Your Honor, I'll admit that the people are in fact just relying on the fact that domestic violence inherently carries some danger, because once Ms. Sherman was released, there was the danger of she knew exactly where Mr. Hammond lived, all of his friends. She has a broader knowledge to be able to continue to cause an emergency that is contiguous.
Do we have any case law? Because, domestic violence and the witness who doesn't show up for court is a very common situation. So it seems like if it were somehow considered to be an ongoing emergency based on a pattern of domestic violence, there would be someone who's raised that issue before.
Yes, Your Honor, I believe I have a case. Let me double check and see if it's the correct one.
We are at 9 o'clock, so I just need to know if Mr. Hammond's statement is excluded, are we proceeding to trial anyway?
Yes, Your Honor.
Okay, call in a jury.
Thank you. It's People v. Farmer has a little bit on point. It's the statements made to the emergency room doctor. I only have one copy that I can provide to them.
It's made to an emergency room doctor. I'm familiar with that concept. Statements made for medical treatment, but what about that would cause you to believe that it relates to a statement made to a law enforcement officer?
I apologize. I thought I had a specific case on point, but I do not, Your Honor.
Based on the information that's provided to the court at this time that Mr. Hammond was at the hospital when he was interviewed by the law enforcement officer, and Ms. Sherman was now in custody and the child was no longer in danger, I don't see how I can characterize this as an ongoing emergency absent any case law that says I get to say that. So at this time, I believe that admission of Mr. Hammond's statement would violate the confrontation clause. I will not admit that statement as it's currently postured. If you're able to lay some other foundation during the trial and want to re-raise the issue, that could happen. But based on the information that's been provided to the court at this time, that. Thank you.
Your Honor, if I may, this is Toby White for the record. I just talked to Mr. Nagel, and if you would give us a few minutes, we might have her plead as charged, given the evidentiary rulings that you've made.
To the DV, yeah.
Okay. We have a jury on their way, so be quite expedient about your considerations.
Okay.
Okay, thank you.
All right. Good. Let's see.
Judge Moore, let me know.
Back on the record in State of Michigan versus Carol Sherman 2401405 FY. We still have Ms. Kashukas. Now we have Mr. White, Ms. Sherman, and I believe we have an agreement. You said plead to the charge. Is that to both counts?
That's correct.
4 and 5?
4 and 5.
Okay. And that's going to be a guilty plea, correct?
That's correct.
Ms. Sherman, you should understand that both counts 4 and 5 are misdemeanors, punishable by up to 1 year in jail. Count 4, malicious destruction of property, also carries up to $2,000 in fines or 3 times the value of the destruction or injury, whichever is greater. And count 5 carries up to $1,000 in fines. Both can carry up to 2 years of probation. You understand those possible penalties?
Yes, ma'am.
Some criminal convictions can have other consequences. If you are a citizen, foreign travel may be restricted. If you're not a citizen, you may be removed from the country, excluded from admission to the country, or denied naturalization as a citizen. You have the right to have an attorney in this matter. Mr. White and Ms. James have been representing you. You have the right to a trial. That could be by jury. Did you have an opportunity to review and have rights and plea information?
Yes,
Did you sign that?
yes, ma'am.
Have you had the chance to ask either or both of your counsel all of your questions?
Yes,
Do you understand that if you proceed with pleading guilty, you will give up these rights? There will not be a trial of any kind.
yes,
If you were on probation, parole, or bond on the day this occurred, May 9 of 2024, and you plead guilty, you could be admitting a probation, parole, or bond violation. As a result of that, you could receive a consecutive sentence for your probation, parole, or bond violation. Are you ready to proceed with your plea?
yes,
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
yes, ma'am.
Put your hand down. Ms. Sherman, on May 9, 2024, were you at a location of 109 North Foster?
Yes,
And is that location in the city of Lansing, state of Michigan?
yes,
And on that day, did you do something to Chevy Tahoe?
yes,
And just to be clear, that Chevy Tahoe, that belonged to someone else?
yes,
Is that Mr. Hammond's Tahoe?
yes.
What did you do to his Tahoe?
I hit it with a bat.
Where did you hit it?
I don't really remember everywhere that I hit it.
Okay, did that make damage to it?
Yes,
Was the value of that damage at least $200?
yes,
Pretty easy to do when you damage a Tahoe.
Yeah.
Okay, and did you in fact have a dating relationship with Mr. Hammond?
yes,
For count 5, as you already said, Mr. Hammond was there with you that day?
yes,
Okay, a person with whom you've had a dating relationship?
yes,
And did you also inflict an injury on him?
yes.
Tell me about that.
I don't really remember anything from the night, but he had an injury to his head.
Okay, I don't remember is not going to be sufficient factual basis. You either tell me what you did or we're not going to be able to do your plea.
I hit him in the head with a bat.
Okay, and did it create an injury that required some medical treatment?
Yes,
Additional questions on the factual basis for either count?
Not completely, Your Honor.
Not from defense.
Ms. Sherman, did anyone make any promises or threats to you to get you to plead guilty today?
no,
Are you pleading guilty of your own free choice?
yes,
Then to the charge in count 4, malicious destruction of property, 200 to 1,000 with a domestic relationship, how do you plead?
guilty,
And to the charge in count 5, aggravated domestic violence, how do you plead?
guilty,
I find your guilty plea to be knowingly, voluntarily, accurately made. The sufficient facts on the record, how much to base your plea, therefore accepted. I will refer you to probation for a pre-sentence investigation. So we can decide whether there's any rehabilitative measures that are appropriate for this. They have to make that statement maybe. Sentencing will be November 14 at 1:30. Just to be clear, all my sentencings are in person.
excuse me, Judge, what was that date again?
November 14, 1:30 p.m. What's gonna happen next is my court officer is gonna take you down to probation to fill out a probation questionnaire and risk assessment. They'll send an appointment for your interview, and then we'll all come back November 14 with that pre-sentence report to figure out what should be the outcome of this case. In the meantime, though, your bond conditions still apply, which include no contact with Mr. Hammond. If you violate that order of no contact, again, arrested without a warrant, bond revoked, contempt of court, up to 93 days in jail, and or $7,500 in fines consecutive to that which you already face. This order is about you, it's not about him. So if he's texting you or calling you, which seems very likely, he's allowed to do that. If you text him back, you take that call, you're the one who could go to jail. Does not have authority to grant you permission to violate this order because it is the court's order, not his order. So if he invites you to meet up with him and you go, you're the one who's risking jail. You understand?
Yes,
Anything else for the record?
Not completely, Your Honor.
Just a caution that with respect to the child, do not have him involved in any communication of any kind to do any kind of child exchange. Thank
Okay,
you, Your Honor.
all right, thank you.
Did you say an officer will take him down or would you?
Yeah,
you
Mr.
walk him down?
Warrensley's gonna take her to probation with the file so that she can do her questionnaire and risk assessment.
Thank you very much.
Yep.